hearing the appeal, the Queen on the application of Derry, and the Commissioner of Her Majesty's Revenue and Customs.
Yes, Mr. Norbert.
My Lord, I appear with Miss Nathan on behalf of the Revenue. My learned friends, Miss McCarthy and Mr. Ripley, appear on behalf of Mr. Derry. As the court will know, this appeal concerns the correct procedure that Revenue is required to follow under the Taxes Management Act 1970, where it wishes to inquire into a claim for carryback share loss relief. As you know, in this case, the Revenue opened a Schedule 1A inquiry into the early claim made on the face of, but not included in the Year 1 return, and a Section 9A inquiry into the Year 2 return.
I'm sorry to intervene before you've scarcely got started, but it would be helpful to the panel if you were able to explain to us in practical terms what the difference is to Mr. Derry's tax position, depending on whether you are right or he is right.
Yes.
On each of the points.
Yes.
Sorry?
Yes, on each of the 2 points of the appeal.
Yes, certainly. So on issue 1,
Yep.
if Schedule 1B does not apply to the claim made, then the Revenue accepts that Schedule 1A would not apply, and therefore the Schedule 1A inquiry would be invalid. However, with as you know, there is a Section 9A inquiry into Year 2, and as I'll show you, the authorities establish, at least so far, that the Revenue, when they close the 9A inquiry into Year 2, can adjust the Year 2 self-assessment to bring into charge or to recover the insufficiency in tax.
So
that's where the cash advantage would
purely,
arise.
it's purely a tax flow issue, is it?
On issue 1.
Yep.
On issue 2, the effect, I think, is disputed, or it's not clear, because the Court of Appeal...
If they win on issue
1,
does issue 2 arise?
no.
No. Good. I'm not saying that necessarily presupposes one, but still. So that's clear, is it?
Yes.
And agreed, yeah.
But in relation to issue 2, Lord Justice Henson, the Court of Appeal, said that the cash advantage still arises, and there's a dispute there because we say that the effect of the Schedule 1A inquiry, as I'll take you to when we go to the relevant provisions, the effect of opening the Schedule 1A inquiry is to stay the Revenue's obligation to give immediate effect to the repayment. And as I'll come on to take... Sorry.
One moment. You say to give effect to the repayment. The repayment's been made, hasn't it?
Well, so what's happened here is that what my Lord Carnworth, in a case called Blackburn and Keeling, described as the freestanding credit, what happens is that when an early claim is made, there is an automated freestanding credit that's applied to the running account.
Oh, yes, I see.
That applies to all years. And so that's not a decision to allow the claim and repay. So the Revenue say, at least, that they are entitled to, that doesn't constitute repayment as such. And so just as it was automatically applied, it can be removed. But the point is that freestanding credit applies to the running statement of account in respect of all years, not in respect of the tax year. So in this case, 09-10.
So, assuming you're right on that, what's the advantage to the taxpayer of winning on issue 2 alone?
Well, that's, I say, where it gets a bit complicated in the sense that Lord Justice Henderson, the Court of Appeal, suggested that cash advantage that I've described applies anyway. So he says, and we take issue with that.
Well, I mean, is that an issue before us? I hadn't picked it up if it was.
Well, it's certainly a potential consequence, because we say that that's one of the problems with his analysis, is that his analysis creates this conflict, whereby he says that you have to open, in respect of year one, a Schedule 1A inquiry into the claim because it's made outside the return, but at the same time you must open a Section 9A inquiry into the claim because it's made out inside the return. And the way my learned friend seeks to square that is to say that really he's talking about two different things. He's talking about the Schedule 1A inquiry into the claim and a Section 9A inquiry into the repayment.
Into the return?
Into the repayment. But of course, we say, how can you distinguish between the repayment is simply a consequence of the claim? You are claiming the repayment. So either the claim is inside the return, in which case it's a Section 9A inquiry, or it's outside the return, in which case it's a Schedule 1A inquiry. He said, the Court of Appeal said that the claim is outside the return, therefore the Revenue correctly instituted a Schedule 1A inquiry, but that they should also have, at the same time, have opened a Section 9A inquiry into the Year 1 return.
You would have to wait.
In order to challenge the calculation of the tax due.
Well,
Right.
I mean, I hope for my purpose that you'll come back to this point when we've had a look at the legislation.
yes.
Because I was hoping there might be a sort of simple explanation of what the difference between the parties is, but sounds
I mean,
yeah. To hope.
I mean, so far it's not clear what difference it makes to the revenue whether they win on point 2 or not.
Well, I think the issue for the revenue is the way the Court of Appeal has expressed it in suggesting that there is this cash flow advantage that arises, so that the revenue have to give effect to the claim, the early claim, and it's only when the Section 9A inquiry into Year 2 is concluded that it can then recover the amounts.
So it's purely a cash flow point.
On Mr. Justice, on the Court of Appeal's analysis, yes. Now, I should say that there is that point about the Year 2 return, that you can, when you close the Year 2 return, remedy the advantage. That's at High Court stage. Permission to appeal has gone to the court, has been granted in. It's the case of Nibs that I'll take you to, but the permission has been granted to go to the Court of Appeal on that. So, of course, depending on the outcome of that, it may if that decision is upheld, then it's just a cash flow advantage.
Mm-hmm. And because you haven't actually paid any money over, but simply applied a credit to a running account, there's no substantial advantage to Mr. Derry from this. From what the Court of Appeal analysed as a cash flow advantage.
Or he get other than the cash flow advantage. Yeah. Yes.
Yeah.
That's on our analysis. Now, it may be said by him that the High Court got it wrong in the Nibs case, and that you can't, in the Year 2 return, correct the insufficiency. Mm-hmm. You have one chance to challenge either the Schedule 1A or 9A into Year 1 claim or return. And that you can't, if you don't do that, you can't remedy it in the Year 2 inquiry. But that's, as I say, that's going to the Court of Appeal.
Doesn't appear to be foreshadowed at the moment in the written arguments that we've seen.
No. No.
Thank you. That's very helpful.
Is that? It does, though. I was going to sort of give you a roadmap and as to where I was going to go, but. Given the court's raised this point, it is a point that I was going to come back to when we go to the authorities. This system is meant to be a simple system. It has to be administered across millions of taxpayers. I'll take you to one of the authorities called Sword Services, where the High Court point out that actually the purpose of an inquiry is simply to give the taxpayer notice that the revenue are going to be inquiring into the return or the claim as it may be. And the reason why the revenue is required to give the taxpayer notice is so that he or she has an opportunity to put their side, to say why their return or the claim is right. That's the sole purpose of the inquiry, the giving the notice of the inquiry. So that a Schedule 1A inquiry notice and a Section 9A inquiry notice are essentially the same documents in substance. They are documents informing the taxpayer that an inquiry is going to be opened and give it so that they have the opportunity. So it's just a label difference. And it's quite extraordinary in my submission that we end up in the Supreme Court on this issue as to is it a Schedule 1A or is it a Section 9A, when in substance the inquiry is the same and you both end up with a closure notice, both end up with a right of appeal to the statutory tribunal to determine whether the closure notice was right or wrong. But
we're here at the Revenue's request.
So, in terms of the structure, I was going to identify the issues, but it's clear I don't need to do that, I think. In terms of the structure, what I proposed to do was to start by identifying and considering the key statutory provisions, because as you've seen in Cotter and De Silva, a clear understanding of the statutory provisions and how they work together is essential in my submission to understanding the answer to the issues. Second, to identify the key principles from the authorities, and there are only 4 or 5 authorities that I'll be taking you to. Third, to look at Mr. Derry's tax return and what's described as his personal tax computation. And then fourth, to address the 2 issues by reference to the judgments of the Upper Tribunal and Court of Appeal. In terms of the key statutory provisions, they are the loss relief provisions in the Income Tax Act 2007 and the self-assessment and claims provisions and procedures set out in the Taxes Management Act 1970. Can we start with the Income Tax Act 2007? That's in MS, or starts at MS page 341. In the hard copy, it's Authorities, tab 2, page 91. The first section I wanted to take you to was section 2, which is page 95 of the hard copy and 345 of the MS copy. And you'll see that this hopefully provides a helpful overview of the Act. The relevant provisions or parts or chapters that concern us are in sub 2, part 2 contains basic provisions about income tax, including A, provision about the nature of income tax, so that tells you about the liability. C is the calculation of income tax liability, so that tells you how you go about quantifying the liability. Then under sub 4, you've got part 4 is about loss relief, including relief for, and for our purposes, the relevant ones, for argument's sake, are A, trade losses, 2 and 3, C, losses in an employment or office, and D, losses on disposal of shares. And our case is to do with Chapter 6, losses on disposals of shares. But the courts below and we say that light is cast on issue 1 by A and C. Then over the page, just finally, the final provision that I'll be taking you to is Part 17.
The other reliefs under Part 5 and Part 6 don't help us. Or 7.
No. Over the page, though, in sub 17, Part 17A, you'll see it says that part contains provisions to be used in interpreting this Act. And you'll have seen Section 1020, which expressly refers to the Taxes Management Act for further information in relation to claims, that provision falls within sub A. So it's of Part 17. So it's a provision used in interpreting this Act. So the first section I was going to take you to is section 4, which is MS 348. It's page 98 of the hard copy bundle. And you'll see that section 4 provides that income tax is an annual tax. So that's sub 1. Income tax is charged for a year only if an Act so provides. So again, here we see the importance of, when looking at these provisions, this is an annual tax. You're looking at a year. And that's confirmed by sub 5. Every assessment to income tax must be made for a tax year. And so we say that that's an important starting point. Then the next provision is section 22, and that is MS 351 and page 98 of the hard copy, page 101 of the hard copy and 351, MS 351. So this is chapter 3, and this is the calculation provision. So this provision, 22 and 23, apply to all of the losses, not just share loss relief. You'll see 22 says, this chapter deals with the calculation of a person's income tax liability for, and again it repeats the A tax year. So again, building on the section 4, which provides, this is an annual tax. 2 is an exclusion for certain types of liabilities, none of which apply here. But for your reference, that is at page 117 of the hard volume. But as I say, none of those liabilities are relevant to this case. Then the next provision is 23, and that sets out the step-by-step calculation that's required to determine an individual's income tax liability. And for our purposes, the relevant step is step 2, but we'll start with step 1. Step 1 identifies the amounts of income on which the taxpayer is charged to income tax for the tax year. Then step 2, deduct from the components the amount of any relief under a provision listed in relation to the taxpayer in section 24, to which the taxpayer is entitled, and again it's for the tax year. And so it's at this stage that the share losses or trade losses or employment losses would fall to be deducted. Mm-hmm. Then step 3 relates to allowances, so personal allowances, for example. Step 4, you then apply the applicable tax rates. And so on. But as I say, for our purposes, it's step 2, which is the relevant step. Then section 24, which is MS 354, page 104. This identifies the provisions referred to at step 2 of the calculation we just looked at. And you'll see that share loss relief is the second one under A. The other two that I was going to take you to, the other two provisions, are trade loss relief and employment losses, and you'll see that trade loss relief is both in A and B. So do you see it's section 72 is early trade loss relief, and section 64 is trade loss relief against general income, and then section 128 is employment loss relief.
And what's the difference between A and B?
I have asked the question, and I think we're still trying to find out the answer. I believe the explanatory note to the Act suggests that it's to do with the legislative history of the provisions, timing.
Do we have the explanatory note in them?
We don't, but we
It's
can.
probably very big.
We can. Would you like?
Some, I mean, this was a wholesale rewriting of the tax acts in the form that I would have been familiar with back in the 80s, as part of the sort of simplification process.
Simplification, yeah.
I think it'd be quite helpful to just see the relevant parts of the explanatory notes.
Yeah. Miss McCarthy says that. Well, no, but I think it's a different question that's being asked. Sorry.
Anyway,
I think the note that Miss McCarthy passed me is to do with. I think she's saying that 2A is to do with companies. But were you asking about the difference between 1A and B?
Yes.
Yes. So I think it's a. Right. So
you can tell us when.
Oh, I see.
It looks as if they split up the categories, and some only apply in particular cases.
Yeah.
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 Thank you. I think I misunderstood my learned friend's notes. Sorry.
Okay.
So, as I say, for our purposes, though, the three that are relevant because they contain similar types of provisions are the trade losses and the employment losses. And just for these purposes, the point I wanted to flag is you'll see that trade losses is in both A and B. Sub A, it's the first early trade loss relief, and B is section 64. And you'll see that trade losses is covered by section 60, which is in MS 349, and it's hard copy 99, so I'm afraid we have to go back on this one.
Sorry, I'm being slow. Trade losses is covered by section 60.
So yes. So can I take you to? So section 60 is at page MS 349 and hard copy 99. So it's back, I'm afraid, in the bundle.
I presume it's just been
Just
put in
copied
the
out of
bundle
order.
out of order.
Yeah. I think this is the only one. And just to I hope answer my Lord Kitchen's question, you'll see that this section 60 sub 1 provides that the chapter covers trade loss relief against general income, which is section 64 to 70, and you recall that 64 was in 1B, so 24 1B, and it also covers early trade loss relief, section 72 to 74, and you recall the reference to section 72 was in section 24 1A, that group of.
And which
losses.
chapter is this?
This is chapter 2, part 4 of chapter 2. And then you'll see sub 2 is the provision relied upon by my learned friend. And this is what the courts below have described as the express signpost to Schedule 1B of the TMA. Can I then take you to, sorry. Then in relation to, so that's trade losses. Can I then take you to employment loss relief? And that is section 128, which is MS 368 and hard copy 118. And the reasons for taking you through the three sections that relate to employment loss relief is that they, as I hope to demonstrate, they mirror the equivalent provisions for share loss relief. So,
And here are we into chapter 5?
yes, this will be chapter 5, because chapter 6 is share loss relief.
We're looking at 1 to 8, are we?
1 to 8, yes. And you see the 1 to 8 begins with, so this is employment loss relief against general income. A person may make a claim for employment loss relief against general income if, and then it sets out certain eligibility conditions. And you see the reference there to the claim for the loss to be deducted in calculating the person's net income, A, for the loss-making year, for the previous year, or for both years. See step 2 of the calculation in section 23 that we've looked at already. If the claim is made in relation to both tax years, the claim must specify the year for which a deduction is to be made first. Otherwise, the claim must specify either the loss-making year or the previous tax year. And then 7 is the equivalent signpost to the one we just saw in relation to trade losses. And the point that I'll be hoping to demonstrate is that that's the only material difference between the employment loss relief provisions and the share loss provisions is that express signpost. Otherwise, they both provide for eligibility and the entitlement in the same way. So the next provision is section 129, which is page 370 of the MS numbering and 120 of the manuscript. And you'll see the heading is how relief works. And then it sets out how you go about deducting. And you see step 1 is deduct the loss in calculating the person's net income for the specified tax year. And then there's a priority rule. So that's employment loss relief. You've got an eligibility section and then a how the relief works section.
So at this point, if you were dealing with employment loss relief and you specified the previous year, then everything's related to that year and subject to the thing which pushes you back to 1B.
Yes. And, sorry.
Yeah. And you say that doesn't make any difference?
No, for the reasons we'll come on to see. But bear in mind, with respect, that a key point to note about the employment loss provisions and the trade loss provisions is they tell you may make a claim. They don't tell you how you make the claim. They don't tell you the procedure that you must follow to make the claim or the mechanism by which the claim is given effect. And we know that the key provisions that do that are found in the TMA, and I believe it's common ground, and maybe I'll find out it's not. It's common ground that section 42 of TMA applies. That's the the procedure governing claims. It's just they say that Schedule 1B doesn't apply.
Because nothing says it does.
Sorry?
Because nothing says it does apply. That's their line, I think.
Yes, but
I'm quite interested. This would be useful to see the introduction to the explanatory note, because the whole purpose of this was to simplify things and make it easier for the ordinary taxpayer.
Yes.
Find his way or her way.
Yeah.
Through.
But as I say, but part of the reason for showing you, as I hope to do on share loss relief, is you'll see that other than that express signpost, it's materially identical.
Yeah.
And so
I think that's common ground, isn't it?
Well, but with respect, the key point is though, if it's common ground also that the Taxes Management Act does apply to the making of the claim, and I'll come on to it when we look at section 42.1.
Yeah. Well,
42.1 expressly provides that applies unless otherwise provided.
Yeah.
So you're not looking for words of
no,
inclusion.
we've read all that. I think, with respect, it's probably better to work through the provision.
I was just seeking to answer
you were answering my question. I'd be better to shut up. But I think we need to see the sequence.
Yes, which is what
you're doing.
So that's employment loss relief. Can I take you to share loss relief, please? Which is MS 372, and it's hard copy 122, and that's section 131.
Can I just ask, you took us to chapter 2, you didn't take us to chapter 3. Does that contain what you call a signpost?
Can I?
Or perhaps you can come back to it.
Can I come back to that? Hopefully somebody will tell me the answer.
I'm just wondering if chapter 6 is unique or if there are others. in the absence of a signpost.
Can I then take you to section 131, and that's headed share loss relief, and you'll see that 131 sets out the eligibility criteria.
So we're now into part 6.
That's correct.
Chapter 6,
Chapter
rather, of part 4.
And so an individual is eligible for relief under this chapter, share loss relief, if A, the individual incurs an allowable loss for capital gains tax purposes, and B, the shares are qualifying shares. Then you'll see that there are various conditions about the company, etc., for these to be qualifying shares. Can I then take you to 132, which is at MS 374, page 124 of the hard copy, so the next page, and you'll see the heading is entitlement to the claim. So if you're eligible, then you'll see that 1321 tells you that an individual who is eligible for share loss relief may make a claim for the loss to be deducted in calculating the individual's net income. And it sets out A, B, and C for the year of the loss, the previous tax year, or for both tax years, and it says C step 2. So again, it mirrors the wording in section 128(1) sub 1 to 5 regarding employment loss relief that we've just looked at. Similarly, the next section, and so, sorry, I'll probably take that a bit too quickly. If we look at 2, it talks about the need to specify the year that's made first, if you've got enough for both years. If not, then you've got 3. You've got to specify either the year 1 or year 2, and the timing. Then section 133 on the next page, again, if we look at the heading, it's got the same heading as we saw on employment loss relief. How relief, sorry.
So 132 follows word for word. Well,
28.
subsection 1 is very similar in substance.
So 1321
Yeah.
mirrors, it's sort of a combination of sub 1 and 2.
Yes.
Because you have to,
and
if we exclude the qualifications for share loss relief are in the previous section that we've just looked at.
Yeah. And then
so-
subsections 2, 3, and 4 of 132 seem to be the same as
Yes,
3, 4, and 5 of,
Yes.
of section 128.
exactly.
Yeah. And then but then it simply stops there, whereas 128
Has the signpost.
has additional provisions.
Yes. And one can carry out the same exercise in relation to 133, how relief works, and section 129, how relief works in respect of employment losses. Do you see that?
No.
It's, in substance, they materially mirror each other. And so in our submission, this chapter tells you about eligibility and calculation, but not the mechanism or procedure for making a claim. For that, we turn to the section 1020, which is 156 of the hard volume, and it's MS 406.
So what was the hard volume?
156, it's the last page of the tab. And so you'll see that it says, and 10202 is the key point for our purposes. It says, for further information about claims and elections, see TMA 1970, more generally, but in particular, section 42.2, 10 and 11. So, one of the claims that this Act applies to is share loss relief. So, that's one of the claims being referred to. And we say that, well, it's clear that section 1020 is an express signpost to TMA generally.
But not to 1B.
Well, but but with respect, 1B is part of TMA, and also when you look at section 4, and importantly in my submission, you look at 42, the provisions that it does refer to. The two, it refers you to 42, and 42.2 is the requirement to make a claim inside a return. Schedule 1A deals with the claims that are made outside a return. So it's pointing you to the fact that claims may be made inside or outside the return.
You're obviously going to have to deal with the fact that the draftsman
Yes,
omitted the subject to provision in relation to Chapter 6.
absolutely. And you'll see that this is also, though, dealt with in, I think it's Cotter, possibly, or De Silva, where I think it's Lord Hodge says that, and we'll come on to it when we look at 4211, which is referred to here, and 4211A, that they effectively, 4211A does the same job as those express signposts. And I'll come on to show you the relevant provision.
Yes, that doesn't really explain.
Why it's omitted. Yeah.
Yes, assuming you're right that it's belt and braces, the draftsman provided the belt for 2 chapters we've looked at, but
Yes.
for a third.
Yes, and there is no escaping that. But nobody has come up with a reason why the draftsman would have intended to do that. Now, other than Lord Carnworth's case of Blackburn and Keeling, which was decided just before, I think, or a few years before this enactment, that was dealing with employment loss, the same provision, Section 380 of ICTA, that covered both employment losses and trade losses. And the argument in that case was that Schedule 1B didn't apply. So it may be, and this is what Lord Justice Henderson says in the Court of Appeal, it may be that the draftsman had that case in mind, and because those were the two, Section 380 was the provision in that case, it may be that that's why the belt and braces was put in. But absent those signposts, as I hope I'll demonstrate when we go to Section 42, and also Schedule 1B, Paragraph 2, Sub 1, it's clear on the face of those provisions that they apply to share loss relief claims, or as in there's nothing in them to exclude the application. And as I've said, Section 41.1, which is a key provision that we'll come on to, expressly provides that Section 42, in its entirety, so that includes 11A that incorporates 1B, applies unless otherwise provided. So one is, in my respectful submission, looking not for words of inclusion, but looking for words of express exclusion.
Does it have to be expressed to be provided for? Surely it's sufficient that that is the true effect of it.
Well, with respect, it'd be surprising if Section 41.1 had that effect. In my submission, the natural reading of Section 41.1 is that you are looking for words of exclusion.
Well, that would assume that the drafter only wished to cover a case where there was an express exclusion, but wouldn't the drafter equally be cautious and say, well, I must include those cases where the context will exclude it or will modify it? So unless otherwise provided, and rather than unless it is in the absence of any provision to the contrary, is what you're saying. What it means.
Well, in my submission, that would be, given the way the Taxes Management Act is supposed to work, that would make it potentially quite difficult to determine whether or not Section 42 applied or not. But with respect, the other point about that is that it's common ground that Section 42 does apply in this case.
Yes.
It's only Schedule 1B. So my learned friends are not arguing that the context otherwise provides for the exclusion of Section 42. And what we say is you can't pick and choose the bits of Section 42 that you want to apply or not. Either Section 42 in its entirety applies, or none of it applies.
I see, it's all or nothing, unless otherwise provided, rather than unless to the extent otherwise provided.
Well, but Section 42.1, and would it help if we go straight to Section 42.1 at this stage? So Section 42.1 is, so that's going to be tab 1. I just want to make sure I can give you the MS number. So the MS is 292, sorry, 1 second, is 281, and it's page 31 of the hard copy. And bear in mind that the heading is Procedure for Making Claims. Mm-hmm. And it says, where any provision of the Taxes Acts, so that includes the Income Tax Act, provides for relief to be given, now we know share loss relief provision provides for share loss relief to be given, or any other thing to be done, and we know that it provides for the making of a claim, on the making of a claim, this section shall, and I say it's this section, it's not Section 42.11a, it's Section 42, shall, unless otherwise provided, have effect in relation to the claim. And it's, if I can just jump straight to 42.11a.
Sorry, I'm not with you. We're now on
Sorry, it's hard copy 31, tab 1, hard copy 31. Sorry, hard copy page 31.
Yeah.
So the heading is Procedure for Making Claims. And, my Lord, I was in sub 1, where any provision of the Taxes Act provides for relief to be given, or anything to be done on the making of a claim. So just pausing there, the share loss provisions do that. This section, so section 42, shall, unless otherwise provided, have effect in relation to the claim. And so it's not saying that certain parts of certain subsections, it's this section. And if we look at sub 11a, I will go through the other provisions, but I just want to cut straight to the point that I think is being raised. If we look at 11a, which is part of the section, so applies, Schedule 1b to this Act shall have effect as respects certain claims for relief involving 2 or more years of assessment. And you'll appreciate that there is an argument about what does certain claims, but assume for these purposes that we're right, if I may, and I will take you to Schedule 1b, because both courts below have held that the certain claims are the claims specified in Schedule 1b. And when you go... Sorry.
Section 1020 that you took us to a moment ago of the 2007 Act, it's drafted in this manner which is novel. I don't know what it was in 2007. And what it actually tells us is that it doesn't say that anything in particular applies. It tells us for further information about claims and elections, see TMA 1970 more generally, but in particular, Section 42, subsections 2, 10 and 11, and Schedule 1A. So we'd look at those, we're directed to look at those for further information.
But it's
and in particular, I mean, why in particular? But we're being directed to Schedule 1A. We're not being, and indeed to subsection 11, which refers to it, but not to 11A and 1B.
But as my Lord says, that provision provides for further information. It's not the provision that tells you what applies. The provision that tells you what that Section 42 applies is Section 42 sub 1. That's the key provision, because it's 42.1 that tells you that the procedure for making claims or that section 42 applies to relief, any provision of the Income Tax Act, or for our purposes, the Income Tax Acts, that provides for relief to be given or anything to be done on the making of a claim. And we know that the share loss relief provisions fall within that. Then it says this section shall, unless otherwise provided, have effect in relation to a claim.
So the words, unless otherwise provided, mean this is the default code for making claims.
Yes, yes. And and as I say, part of that code, part of that section is, as I say, I jump straight to 11A, the application of Schedule 1B. But before we go to Schedule 1B, can I please just go through the subsections of Section 42?
Yeah, and again, one's looking for a reason why 1A is referred to in the 2007 Act and 1B isn't. I mean, one possible explanation might be that there is already specific reference to 1B in the chapters that we looked at where we saw it referred to.
Yeah, but with respect, it may be the level of detail that's been gone into in the provisions, because the ones that are identified are simply the ones that tell you more about the mechanics of the making the claim in terms of where you make it. So 42.2 is you must make it in the return, and 11 and Schedule 1A are the ones that provide for it making it outside the return. So it's those. So it's dealing at it with at that high level in Section 1020. I think that may be relevant. That the ones referred to are dealing with it at that high level.
Yes. There's nothing in the explanatory notes which helps us on that.
As I say, we will get a copy. But can I go through though, please, because it does show when we go through how this is as Lady Arden described it, it's a code for how you make the claims, and Schedule 1B is an integral part of that code. So when we go through, we can see Section 42 sub 1A is the requirement to quantify the claim. Now, again, clearly, that subsection is going to apply to the making of a share loss relief claim, but it's not one of the subsections referred to in 1020. Then we see 2 is the point that a claim shall not at any, it says, subject to subsections 3, 3ZA below, where notice has been given under section 8, 8A, 4 or 12AA of this Act, a claim shall not at any time be made otherwise than being included in a return under that section, if it could, at that or any subsequent time, be made by being so included. So that's the converse of 1A. But the key point is that you only get into 1A if Schedule 1B disapplies, because Schedule 1B disapplies subsection 2. And that's the gateway into 1A. The next relevant part that we need to look at is 11.
You wouldn't know that from Section 42. We've got to go to 1B to find that out.
Yes, and Lord Hodges' decision in
Again,
Potter and De Silva.
It says subject to all these provisions, going out to ZA, but not to 1B.
But 11 though, sir, if you, my Lord, when you then go to the next relevant one is 11, it tells you that Schedule 1A to this Act shall apply as respects any claim which is made otherwise than by being included in a return. So you know from 11 that there are claims that for which 11.2 does not apply. And then, as I say, it's 11A that says Schedule 1B to this Act shall have effect as respects certain claims for relief involving 2 or more years of assessment. And so, as I say, my submission is that Section 42(1) tells you that Section 42 applies, and 1B is incorporated by 11A, subsection 11A.
My description of it was default code, not just a code, a default code. And the wording of subsection, is it 11, which says 1B has effect as respects certain claims,
Yes.
rather confirms it's a default code. There will be certain claims which are not covered by that provision. You may say they're irrelevant, but it's making the point that this is not a completely comprehensive code.
With respect, the default code is Section 42,
Yes.
and Section 42 provides for claims to be made in the return, that's sub 2, and claims to be made outside the return, that's sub 11. 11A is doing something different. 11A says that Schedule 1B to this Act shall have effect as respects certain claims for relief involving 2 or more years of assessment. It's not saying, so that's not applying a different code or so the code is section section 42. That code includes claims inside a return 42(2) and claims made outside a return subsection 11. 11A, what 11A is doing is saying that Schedule 1B shall have effect as respects certain claims. So those claims are still subject to, those certain claims, the Schedule 1B claims, still fall under Section 42. So they still fall within, they're not taken inside or outside the default code. They're part of that code.
And then subsection 11A throws you into Schedule 1B.
Yes?
And paragraph 2(2)
Yes.
then disapplies section 42(2),
Yes.
and that then throws you into
1A.
Schedule 1A.
Exactly.
Is that right?
Exactly.
But you're still, on your submission, within section 42.
Yes.
And that structure.
Yes.
But I may be jumping ahead, but the Schedule 1B heading is claims for relief involving 2 or more years, whereas 11A, Section 42, 11A, says that it's certain claims for such relief. So we've got to narrow it down somehow.
And the way you do that is by the certain claims are those claims that we see. First of all, it's should we go to, just to answer that question, and we might as well go straight to Schedule 1B. You'll see that Schedule 1B is at page, hard copy page 68 and manuscript 318.
I'm so sorry, manuscript.
Sorry, manuscript 318.
Okay.
And it's hard copy 68. Paragraph 1, I don't think we need to detain long over, that's a sort of definitional. Any reference to a claim, any reference to the amount. But the paragraphs that follow are the certain claims described in 4211A. And so you'll see that paragraph 2 specifies the claims that this paragraph applies to. It applies where a person makes a claim requiring relief for a loss incurred or treated as incurred, or a payment made in 1 year of assessment, the later year, to be given in an earlier year of assessment, the earlier year. So that's the first type of claim, one of the certain, that's what the first claim. And there's no dispute that on the natural language of that, share loss relief claims falls within that description just as much as employment losses and trade losses. The next type of claim is paragraph 3. And you'll see effectively as you go through 3, paragraph 4, paragraph 5, they're all different types of claims. They apply to farmers' fluctuation of earnings, artists who also have that same issue of fluctuation of earnings over years. So different types of claims that they can make and how you make them. So, and this is what the courts below have held, that where in section 4211A there's a reference to certain claims, that Schedule 1B applies to certain claims, it's the claim specified in Schedule 1B, and it's the claim specified in, one of those claims is the claim specified in 2.1, paragraph 2.1, another one is the one in 3, 4, 5, etc. And I say that's the reading of both the upper tribunal and the Court of Appeal.
Now, the paragraph 2,
Yes.
subparagraph 3, is inconsistent with section 132 of the 2007 Act, isn't it?
Yes.
Yeah. And it's also inconsistent with...
Sorry, inconsistent.
Inconsistent.
Yeah.
And it's
Well-
also inconsistent, for example, with section 128.
Yes.
But 128 addresses the problem by making itself subject to...
It's
Schedule
different.
1B.
It's different, but the key point is that it's Schedule 1B. We see that Schedule 1B, the fact that you don't have a conflict, the fact that they work together is demonstrated by the employment loss and trade loss provisions that both relate it to the later year.
Well,
Don't relate it to the later year. It's the effect of Schedule 1B, paragraph 2.3 of Schedule 1B that relate it to the later year.
yes. Whereas the provisions in Chapter 5 of Part 4 of Chapters 5 and 6 of Part 4 of the 2007 Act require the individual to specify, the claim has to specify either the year of the loss or the previous tax year.
Yep.
So if you stop there,
Yes.
he can make the claim for the relief in respect to the previous tax year.
But
Now that,
yeah.
in section 128, that's expressly made subject, this chapter is subject to
Yes.
paragraph 2 of Schedule 1B,
Yes.
which tells you can't do that.
Yes.
Now,
It comes down to the same point that
Yeah.
my answer to that is, but section 42.1, the effect of section 42.1 is to apply Schedule 1B to all claims that, to those claims that fall within the certain claims in Schedule 1B
Yeah.
are brought in by section 42.1.
yeah.
Yeah, I
And-
mean, this
and-
is the point. And
Yeah.
But it's a very odd way of doing it, isn't it? Because, I mean, on its face, Section 132 is headed entitlement claims, giving the taxpayer something, and it's telling him what he's got. And what he's being given is a choice, whether the year of the loss or the previous tax year.
Yes.
So that's his right. And that's confirmed by Section 132, which is the main act. You're saying that that's taken away from him by a rather obscure mechanical schedule to an earlier act.
Well, with respect, section 132 is setting out how it works.
It's an entitlement claim.
Sorry, yes. And then the next one, though, is 133. Yes. And the next one, though, is 133 as to how it works.
Yeah.
But both say you may make a claim. Both are worded in exactly the same way. And one signposts you expressly into Schedule 1B.
Yeah, well, I understand the point.
And then, yes, no.
I mean, it just seems to me, on the face of it, a rather odd way of doing it.
And what neither party has been able to provide the court, certainly the courts below, with any reason is why would Parliament intend to distinguish in that way, to have a different, for it to the calculation, etc., to apply differently to share loss relief and, for example, employment loss relief.
Well, it wasn't a frolic by the parliamentary draftsman. He must have had bill instructions, which he's followed.
Well, as I say, and that's why you then, an explanation is the explanation of Lord Justice Henderson.
We don't have
Blackburn.
to explain it, do we? We have to look at what the language
Yes.
says and its natural meaning.
Yes, but with respect, the only way to get to a position whereby Schedule 1B does not apply is to get around Section 42(1).
Yeah.
Um,
Well, you say that. I mean, what you're asking us to do is to say that the later Act, the 2007 Act,
yes.
is to be read in this provision as being subject to a provision in the earlier Act by virtue of a section in the later Act which tells us to see the earlier Act for information.
No, with respect, that's not my submission. My submission is that the later Act is written with the earlier Act in mind, and I don't rely here on Section 1020. That's the provision I think my Lord is referring to.
Yes, it is. You're not relying on that.
I rely on Section 42(1), principally.
But it's elementary. If there's an inconsistency between a later Act and an earlier Act, then the earlier Act is impliedly superseded.
But with respect, in my submission, it's not an inconsistency because it's common ground that the procedure for making the claim is set out in Section 42, and that procedure provides for a specific regime to apply to claims that cover or relate to or cover multiple years.
How does the reader get to Section 42 other than through Section 120?
So in this way...
Sorry, 1020.
Yeah, because the earlier provisions tell you may make a claim, but they don't tell you how you make that claim. And that's why Section 42(1) is so important, because that and bear in mind that, with respect, please, but I would ask the court to bear in mind the opening words of 42(1), which says, where any provision of the Taxes Acts, so that's the Income Tax Act.
But why isn't Section 132, subsection 1, paragraph B, an other provision for the purposes of Section 42, brackets 1, close brackets? Because that is telling you that you can claim for a previous year.
But with respect, the important point with respect here is that what 42(1) is doing, it's telling you that this section applies. So in my submission, that as I say, it's common ground that this section 42 does apply to share loss relief claims.
Yes, but it can only apply according to its tenor. And its tenor, i.e., it includes the words unless otherwise provided. And it can be excluded, of course, by implication, but the parties' agreement can't bind the interpretation.
But with respect, if that's right, then you're left in a position whereby there is no procedure to make the share loss relief claim.
No, unless to the extent that is otherwise provided. So you've got a default code in 42.
But with respect, that's...
Well, isn't that what unless otherwise provided?
That would require reading into Section 42. That would require reading into Section 42(1). This section shall apply, or to the extent, because you'd have to read inward, because this is saying that, and as I say, it's common ground, or I'll leave aside the fact it's common ground. In my submission, any provision of the Taxes Act provides for relief to be given or anything to be done on the making of a claim. The share loss relief provisions fall squarely within that part of Section 42, sub 1. Fine. This section shall, unless otherwise provided, have effect in relation to the claim. Well, as I say, in my submission, that brings in all of these provisions in circumstances where, and an indication is given by 1020, that both Section 42(2) and Schedule 1A, so both Section 42(2) and Section 42(11), and that applies for claims in the return and outside the return, are relevant.
Can I ask you a practical question? Keeping in our minds the difference between the procedure for making the claim and what year's return you make it in and so on,
Yes.
and your eligibility to the relief and what income it actually counts against.
Yes.
How does it actually work if you go into Schedule 1B as compared to the relief that you were offered by virtue of Section 132? You get your choice, carry back this year or
Yes.
carry forward. I think where we are in 1B is paragraph 2, subparagraph 4.
Yes.
How does that actually work? I can't put it into sums.
Sure. So we know it relates to the later year, so year 2, but the way you calculate the sum is the A and B. So it shall be the amount equal to the difference, and this is what I think in De Silva was called the counterfactual computation. So you take the amount in which the person is chargeable to tax for the earlier year. So in this case, it would be the not the 95 figure, but the slightly higher figure that includes the tax deducted at source. And then you say, and the amount in which he would be so chargeable on the assumption that effect could be and were given to the claim in relation to the year. So you would work on the basis that the income was less by 414,000, in this case, the loss. You times that by 40%.
What I'm really getting to is, does that mean that you are getting relief against your net income in the year
Yes.
preceding?
Sorry.
Or in the year...
Well, no, it's not... the amounts will be the same, but...
It happens in the later year's
Yes.
tax
Yes.
calculation.
But it's calculated
but
by
the
reference
amount
to- yes.
is the same as it would have been if it had been done the year before.
Yes.
Right.
And it's a cash flow point then, is it? I mean,
Seems to be.
Yeah. Yes. As my learned friend says, by reference to the year one's figures
what's the point of that? I mean, it's an awfully complicated way of doing
of getting to the same.
Yeah.
Yes.
You have this rather elaborate deeming provision. You seem to be given by 132 a perfectly straightforward right. And then somehow you sort of have a complicated deeming provision to get the same figure, but to get it in a later year. Is there any point in that? If I'm trying to look into the draft mind.
Well, but as I say, but with respect, as I say, you come back to the same point, which is that it applies.
But I mean, this was based on preceding provisions of ICTA, wasn't it? I mean, it wasn't a new thing in 2007.
Yeah, but also though, you're in the situation whereby it comes back to the same point. But you're in the situation whereby it applies to. There's no doubt. I mean, almost you can put to one side share loss relief for these purposes, and you look at the equivalent loss relief provisions. Employment loss is the obvious one because of the mirror in the wording. Parliament has intended that it applies to employment loss. Why not the identically worded share loss relief?
Yeah.
I mean, maybe it's driven by the year the loss is suffered. And so Parliament did not think it appropriate that you should have the benefit of it a year earlier than the year the loss was suffered.
Well,
You can carry it back in one sense,
Yeah.
in that you can
The only thing
use
is
your
that-
previous year's figures for the purpose of the calculation.
The only
You don't
thing is-
actually get the benefit of it
well,
until you get to the year in which you suffered the loss.
no, I think the problem with that is that the intention behind Schedule 1A and the ability to make the early claim is actually to give the individual the cash flow, is to get the cash advantage. So you do, so that you get the advantage earlier. Because although you've suffered the loss in year 2, you're able to make the early claim, so you get the money, so that you get the money earlier than you would otherwise be entitled to it.
Yes.
And of course, yes. Those behind me are passing up the note to say that was the intention of Parliament, was to get the early benefit, which I believe is what I've just said. My Lord, so we were in paragraph 2, we sort of jumped ahead. So you have in sub 2 the disapplication of the section 42(2) requirement to include the claim in the return. 3 is the claim shall relate to the later year. 4 is that computation. 5 is not relevant. And then 6 is effect shall be given to the claim in relation to the later year, whether by repayment or set-off, or by an increase in the aggregate amount given by section 59B(1)(b) of this Act, or otherwise. And it's that or otherwise wording that the Supreme Court in De Silva referred to, and the High Court in Nibs relied upon in saying that the Section 9A inquiry into Year 2 could amend the Year 2 return to increase the tax payable.
I'm sorry, which page are you?
Sorry, I'm on the hard copy 70, tab 1, 70.
Yes, thank you.
And it's just those words or otherwise at the end of sub 6.
Yes.
Hopefully, if I have time, I will take you to the relevant paragraphs in Nibs.
Thank you.
Can I just take you very briefly then to Schedule 1A, just working backwards? And so Schedule 1A is it's manuscript 295 and it's hard copy 45.
Okay, I'm afraid we're not quite so old-fashioned. It's MS's memory stick.
Sorry. I was trying to stick with MS. So MS 45. Can I then take you to paragraph 1, which is MS 296 and hard copy 46. In the schedule, claim means a claim as respects which this schedule applies, and so this schedule applies by reference to section 42 sub 11. So it applies to claims made outside the return. Then paragraph 2, subject to the provisions in the Taxes Act, for a claim to be made to the board, every claim shall be made to an officer of the board. Then sub 3, a claim shall be made in such form as the board may determine. There is no prescribed form. Then paragraph 3, which is MS 301, hard copy 51. Here you find the equivalent provisions to the section 9ZA and 9ZB correction provisions in relation to a section 9A inquiry. Mm-hmm. So here it's where where there's an obvious error or an error of principle, either the taxpayer or the revenue can amend to correct.
On which subparagraph are you now?
So this is paragraph 3, hard copy 51.
Thank you.
Apologies.
Yeah.
So just the point I'm making is the equivalence between the section 9A and the schedule 1A inquiries. Similarly, then if we go to paragraph 4, sub 4, sub 1 rather, an officer of the board or the board shall, as soon as practicable, after a claim other than a partnership claim is made or such a claim is amended under para 3 above, give effect to the claim or amendment by discharge or repayment of tax. So that's the obligation to give effect as soon as possible. But you see that's though then it's subject to 3, and you see that where sub 3, where any such claim or amendment is inquired into by an officer of the board, A, that subparagraph shall not apply until the day on which, by virtue of paragraph 7.1 below, the inquiry is completed. However, the officer may, at any time before that day, give effect to the claim or amendment on a provisional basis to such extent as he thinks fit. So it has this, so starting point is the obligation to give effect as soon as possible. However, that is stopped if you open an inquiry, but even if you open the inquiry, you can choose to give provisional effect, pending the completion of the inquiry. So you have those stages. That's so that's paragraph 4. Then paragraph 5, and that's consistent with the objective. The objective being to give this early, the cash flow advantage. Then paragraph 5 is the power to open an inquiry, and that's the equivalent of section 9A(1). Can I just give you a reference? Because at the beginning I made reference to sword services and the purpose. I'm not sure I'm going to have time to take you through all the authorities, so can I just give you a reference? It's MS 1031. It's hard copy, authorities bundle, tab 12, page 780, and the relevant paragraph is paragraph 71. And that's just the provision that talks about the purpose of the inquiry, to give the notice so that the taxpayer can give their side.
This is NIBS, is it?
No, this is sword services. It's one of the accelerated payment notice judicial reviews.
Sorry, it was...
Tab 12 is NIBS.
Oh. Then I've given you a wrong reference. The reference should be, apologies, tab 16. And hard copy, it's 791, paragraph 71. And what's the MS? And MS, it's 1031. Thank you.
This is sword services.
Yes, and it's just paragraph 71. Sorry, I wasn't going to take...
No, but I mean, we need to get the right reference.
Understood. I'm grateful, my lord. There's another relevant feature of paragraph 5, and that is, well, so 5.1 is what you have to do, and as I say, it's the same, mirrors section 9A1. But also, do you see subparagraph 3, a claim or amendment which has been inquired into under subparagraph 1 shall not be the subject of, and then A, further notice under subparagraph, or B, if it is subsequently included in a return, a notice under section 9A1. So in this case, when the revenue opened their inquiry into year 2, they notified the taxpayer that that year 2 inquiry would run in tandem with the Schedule 1A inquiry, so as to stay consistent with subparagraph 3. Paragraph 7, which is MS 310, hard copy 60, is the completion of the inquiry, so the issuing of a closure notice. And you see sub 3 must either allow the claim or disallow the claim. And then paragraphs 9 and 10 give you your right of appeal against the closure notice.
I'm sorry, what page are you on?
So hard copy 63, MS 313.
This is paragraph 9.
Paragraph 9.
Yes, I'm
Sorry.
Yep, fine, thank you.
I was saying paragraphs 9 and 10. The reason for 10 is because 10 tells you that that's an appeal to the special commissioners. So it's the statutory tax tribunal. So, and the point of showing you those is just to show you the mirror between the Section 9A inquiry and the Schedule 1A inquiry.
Yeah.
So in substance.
Yeah. Can you just tell me that the Schedule 1A and 1B came in 1996, I think. Well, that's what it says.
Just
As
before self-assessment.
Yeah.
1B did.
1B, well, 1A, when did 1A come in there? I mean, they're both by way of amendment of
the original.
taxes. I mean, the Taxes Management Act, although it goes back to 1970, has been amended.
But please bear in mind that obviously this is around the time of self-assessment.
It's the Finance Act 1994, came into effect 1996, 97.
I mean, the point I'm making is that, as I was going to make, is that the provisions for share relief and employment relief are derived from provisions of ICTA 1988.
Yes.
Which were in effect before these provisions of 1A and 1B came into effect. And has anyone looked into how these things worked before the 2007 Act? Because it may throw some light on why there was a difference.
Can I perhaps take instructions on that?
Yeah.
Yes,
I'm not asking you to do it on the field. It doesn't look as if anyone has, but I was just looking at the explanatory notes, and it doesn't tell you much about these provisions other than they were based on equivalent provisions of ICTA.
Yeah.
And so one would have thought they might. Anyway, it may help, it may not.
Can I just, as I'm conscious of the time, can I just, I was going to actually start at the beginning of the Taxes Management Act and run through some of those earlier provisions. And the reason for that is that they are directly relevant to issue 2. And just why we say that the Court of Appeal were wrong on issue 2. And when we say, when you understand those provisions as a whole, one can see where the Court of Appeal have gone wrong.
Yeah. It's useful anyway, because Section 42, subsection 2, tells us that if you're somebody who's received a self-assessment notice under Section 8, then that's how you've got to make the claim, by including it in the return. So, which takes us to the beginning of the Act anyway.
Exactly. I'm grateful.
Can I just, I mean, there are two rather distinct issues here.
Yes.
It's on the second one that you got permission to appeal, because you won on the first one.
Sorry, on the second one, I think, so we won on issue 1,
Well, it depends.
which is the issue.
Yes, I know, and so you got leave to appeal on issue 2.
No, I've got permission leave to
Well,
appeal.
whatever it is. I mean, what I'm trying to get at, from we gave permission on terms as to costs.
Yes.
Because we thought that the revenue was saying there are important points of principle here.
Yes.
As between issues 1 and 2, do both of them raise important issues of principle, or is there a difference between them in terms of significance?
Well, I think they both raise important points of principle. The issue 1 raises as to whether Schedule 1B applies or not, as we know, does have very significant consequences.
Well, does it? I mean, it seems to be just to shift it from one year to the next, which doesn't sound very significant.
Well,
I really want to be helped, from the point of view of the revenue. Some cases, the revenue comes in front of us saying there's sort of hundreds of millions of tax are turning on this. Issue 1, it doesn't sound as if it is. But issue 2, I suspect, does affect quite a lot of cases.
But also issue 1 is going to affect potentially quite a lot of cases, because everybody's been proceeding on the basis that a Schedule 1A inquiry is the appropriate route, whereas if Schedule 1B doesn't apply, then Section 9A was the appropriate.
There will be an awful lot of ones which are out of time.
Yeah, I mean, you've seen De Silva was itself, it took 10 years to get up to the, related to a tax year earlier. That's all potentially subject to the Year 2 NIBS Section 9A inquiry point, that you can correct it at that
Anyway,
stage.
we work on the assumption they're both of considerable significance.
Can I, as I say, because I agreed with my learned friend that we'd divide the time equally. So I think I've got till 12:30. Can I just very quickly take you through the earlier provisions, although I do feel like I'm doing the legwork in terms of the provisions, understandably. So what I was going to do was to take you through the earlier provisions of TMA, because as my Lord Rees says, they are relevant to issue 2, issue 1 rather, but also in my submission important in relation to issue 2. So can I start please with section 8, which is MS7, and it's hard copy 7. So 8.1, personal return. For the purpose of establishing the amounts in which a person is chargeable to income tax, and MS 257, for the purpose of establishing the amounts in which a person is chargeable to income tax and capital gains tax for a year of assessment, and the amount payable by him by way of income tax for that year, he may be required by a notice given to him by an officer of the board, A, to make and deliver a return containing such information as may be reasonably be required, and also to deliver with the return such account statements and documents relating to the information contained in the return as may be so reasonably required. 1AA says, for the purposes of subsection 1 above, the amounts in which a person is chargeable to income tax and capital gains tax are net amounts, that is to say, amounts which take into account any relief or allowance, a claim for which is included in the return. So that's, you see, where the relief is would be the loss relief. B, so A is dealing with chargeable, so the tax chargeable. B, the amount payable by a person by way of income tax is the difference between the amount in which he is chargeable to income tax and the aggregate amount of any income tax deducted at source and any tax credits to which sections 397 and 397A of the employer apply. Now, just for your note, those sections are tax credits for distributions of UK and non-UK companies. But the important point to note there, though, and this is mirrored in section 9, 1A and 1B, is that where it's there talking about the tax payable, it defines that as being chargeable amounts less tax deducted at source. It's not actually the amount of the payment that you will make, because, for example, as we'll come on to see, you will have already made payments on account. And so in my submission, it's important to understand what the reference to tax payable is there. The next reference is A2, which is over the page. Every return under this section shall include a declaration by the person making the return to the effect that the return is, to the best of his knowledge, correct and complete. So, and in my submission, this will be potentially relevant when we come to look at the tax return. Then when we look at section 9 is 12 of the hard copy MS 262, and you'll see that the paragraphs in 1AA are mirrored here, but this is 9.1 is important because it's the self-assessment. Subject to subsections 1A and 2, every return under section A or 8A of this Act shall include a self-assessment. That is to say, an assessment of the amounts in which, on the basis of the information contained in the return and taking into account any relief or allowance, a claim for which is included in the return, the person making the return is chargeable to income tax. So in your tax return, you've got to make a self-assessment in those terms. And then B, you also have to make an assessment, a self-assessment of the amount payable by him by way of income tax, but it defines what that means. That is to say, the difference between the amount in which he is assessed to income tax under paragraph A above and the aggregate amount of any tax deducted at source and any tax credits, which we've already seen. But again, you see there that the self-assessment as regards to tax payable is very specific. It's narrowly defined. It's the chargeable tax less the tax deducted at source. Again, that's not the tax that you will actually have to pay or the amount you will actually have to pay on the 31st of January, as we'll come to see, the year after. Then when we look at 9.2, you'll see that there's a difference between the person who submits his return or her return before the 31st of October and after. If you do it before the 31st of October, you can leave it to the revenue to do the sums. If you do it before, you have to do it yourself. And an important difference between the pre-31st of October and post-31st of October taxpayer is if you're pre-31st of October, you can do it on paper, so complete the returns on paper. Whereas if you do it after the 31st of October, it has to be electronic. And there's a difference between the paper and the electronic forms. As you can imagine, if you request when it comes to the tax calculation pages, if you request the paper tax calculation pages, you've got to input the figures manually. Whereas if you do it electronically, the algorithms in on the computer system take all of the self-assessment amounts that's in the body of the return and automatically do the calculation and populate the box 1 figure. Importantly, and that helps the taxpayer to get to the right sum, to fulfil his 9(2) obligation, because one has to remember that tax returns are not just to be completed by those with sophisticated accountants, it's individuals as well. They can be quite complicated. Now, the point about the paper return, though, is that the Cotter case was a paper return case. And in my submission, it may well be relevant when we come to consider Lord Hodge's comments in paragraph 27, when he says that Mr. Cotter could have called for or requested the tax calculation pages. They would have been the paper pages, because it was a paper return, so he would have manually have filled in box 1 and 2. And so when we come on to it, in my submission, when you look at paragraph 27, it may well be that Lord Hodge was referring to, when he talks about completing the self-assessment calculation himself, he would have manually have been able to do it incorrectly by deducting the loss, the year 2 loss from year 1, whereas on the electronic one, you can't do that because of the algorithms.
We'll tell you that's where this is going in due course.
Oh, I will do.
I mean, all this, we've got to remember, this is all brought in the Finance Act 1994,
Yes.
with effect from a year or so later,
Yes.
as part of self-assessment regime.
Yes.
And this applies to these provisions as it does to Schedules 1A and 1B.
So can I just answer your question, though, Lord Carnwath, in terms of why it's relevant? It becomes relevant when we come to issue 2, when it comes to looking at what did Mr. Derry do in his tax return. Because...
No, I mean, I understand why it's relevant,
Yes.
but if you're going to be qualifying what Lord Hodge said in Cotter, I'd prefer to do it when we've got it in front of us so we can see what it says.
Does that mean that the algorithm can prevent you making a claim under Section 132 to attribute the loss to a previous year?
Yes. Yes.
Because of Schedule 1B. That's how it's all been set up.
Yes.
Thank you.
Right, you're wrong there. Then the algorithm may be wrong in law.
Yeah. No. So that's 2 and 3. I was then going to take you to 9ZA and B are at MS 266. And it's hard copy 16 and 17. I don't need to take you to those. Those are just the correction provisions that I showed you the mirror of. Section 9A is MS 268, and it's hard copy 18. And again, that's just the mirror of the Schedule 1A. Can I then take you to MS 287, hard copy 37? And so this is the provision that requires, is the obligation to make payments on account. And so you'll see that this section applies to any person as regards a year of assessment if, as regards the immediately preceding year, he is assessed to income tax under Section 9 of this Act in any amount, and that amount, the assessed amount, exceeds the amount of any income tax which has been deducted at source. So, and you see the amount of the excess, the relevant amount, is not less than such amount as may be prescribed. We don't need to worry about that. But you'll see that the obligation to make payments on account arises if your preceding year self-assessment is of a positive value, a value that exceeds the amount deducted at source. And if that's right, you'll see sub 2 requires you to make two payments on account, one on the 31st of January in the tax year and one on the 31st of July after the end of the tax year, of 50% of the relevant amount. What 3 and 4 then do, well, just pausing there. So therefore, when you come to look at what is the payment you actually have to make when you, on the 31st of January after you put in your return, it's not the Section 91B figure, it's that figure less the payments on account you've already made. And when we come to Section 59B, you'll see that's described as the difference is the balancing payment. That's the payment. It's the Section 59B payment that you've got to make for the year, as well as any 59A payment for the, as it were, for these purposes, the year 2 year. Because that's your first payment on account. Now, that's the first point that, as I say, hopefully I'll come to demonstrate is relevant. But the second point is this, is that subsections 3 and 4 enable you to make a claim in your year 1 return not to make payments on account for year 2, or to make a reduced payment on account if you think that your income for year 2 is going to be less than your income for year 1. But you're only ever going to do that if the 59(1)(a) and B calculation gives rise to a positive figure, because it's got to be 50% of something. And we know in this case that Mr. Derry, when I come to show you the year 1 tax return tax calculation pages, he did make such a claim. He made a claim to reduce his year 2 payments on account. Now, he can only have done that if he was self-assessing himself for year 1 in a positive figure. If he was self-assessing himself as a minus 70,000 figure, well, there would be no payment on account to make. The obligation to make a payment on account in year 2 wouldn't have arisen, so there'd be no reason to make a claim. And so in my submission, the legal submissions that are now being made to the courts, that Mr. Derry self-assessed for year 1 in this minus figure, is inconsistent with his own claim in that same year 1 tax return to reduce his payments on account for year 2 to this 0 figure. But I'll pick it up when but I just, as we're here, just wanted to flag the point. Then we go to 59B, and that is hard copy 42. And it's section 59, MS 292. And so this is the balancing payment that I was referring to. So this is the difference between your section 91B tax payable and the section 59A payments on account that you've already made. So therefore, on the 31st of January, the taxpayer...
Sorry, which section are we looking at now?
Sorry, 59B. So it's MS 292.
Yes, subsection.
So 59B1. So therefore, on the 31st of January, the taxpayer will be required to make at least 2 payments. Mm-hmm. The Section 59B balancing payment in respect of the year of assessment for which he's filed his self-assessment return and made payments on account, i.e. year 1. And he will also, or she will also have to make their first payment on account for the current year of assessment for which they have not yet filed their self-assessment return, as the year is not complete. Year 2. And so when we come to the calculation pages and we see that the heading above boxes 13 to 15, where it talks about adjustments to tax due, in my submission, properly understood, that's not referring, as the Court of Appeal proceeded, to the section 59, the section 91B self-assessment of tax payable that doesn't take into account payments on account, etc. It's actually referring to the amount you're actually going to have to pay on the 31st of January. But I'll come on to develop that if I may. And what that does in my submission is it reflects the ongoing account between the taxpayer and HMRC. And therefore it's important to distinguish between three things. One, the Section 91A chargeability for the year of assessment. Two, the 91B payment liability for the year of assessment, defined as chargeable sum less tax already deducted at source. That's Section 91B. And three, the 31st of January payment sum, which reflects the ongoing account which covers payments and repayments relating to earlier and later years, as well as payments on account already made in respect of the year of assessment. And in our submission, just to headline it here, the Court of Appeal failed to distinguish between 2 and 3. Because what the year 2 tax repayment that he was claiming did was to reduce the 31st of January sum that he actually had to pay. Well, it does from the Court of Appeal's perspective, because the court it's only by saying that that box 15 relates to the Section 91B self-assessment that those boxes feed into or become included in the return for Cotter de Silva type purposes. And so that's how the court arrives at the conclusion that the revenue were required to open a Section 9A inquiry, because, according to the Court of Appeal, box 15 and presumably 13 and 14 are included in the return, because the Court of Appeal say they adjust or they feed into the Section 91B tax payable. And we say that's the false premise that, as I hope if I have time, propose to show you, that permeates the reasoning throughout the relevant paragraphs.
But the amounts you calculate under the earlier provisions do feed into the calculations under the later provisions, don't
Yes,
they?
absolutely. But they provide the starting point, because you start with your Section 91B figure, you then take off your Section 59A 2 payments that you've already made. You then add in the Section 59A payment for year 2.
Yeah.
And then you also make any adjustments for the box 13, 14 and 15 figures that relate to, box 13 and 14 relate to earlier years, so increases due to the earlier years, or 15, the year 2, the later year repayment of tax, none of which feed into the tax, Section 91B tax payable for the 09-10 year. They simply feed in, they are relevant to how much am I actually going to have to pay, taking into account all of those matters. So that's 59B. That was all. Those were the only provisions I was going to take you to. I'm conscious it's 12:15, so I've got 15 minutes left. I was going to take you to Cotter and De Silva. We've set out the relevant provisions in our printed case and the principles that we derive from them. They do form an important part of our case.
Yes.
But can I deal with it in this way? Can I deal with it by, in terms of De Silva, can we go to that first, please? It's MS 881 and it's tab 14A.
Where is this dealt with in your case?
So in our Whippen case, we have a section that starts at paragraph 21 and goes through to 23. But you see what we've tried to do in those paragraphs is encapsulate the principles that we derive.
Yeah.
But obviously there's one thing doing it in pen and there's another thing developing it orally. But can I just try and do it quite quickly? So De Silva is MS 884. It's tab 14A of the hard copy bundle. Can I just... You'll see that paragraph 4 is at MS 884. It's 633 of the hard copy. I just want to point you to the fact that the De Silva Year 1 return contained the equivalent box 15 entries. So that wasn't dealing with share loss relief. But you'll see that there it's the equivalent box 15. It's got a different number because it's a return from 10 years earlier. But it's got the equivalent box 15.
It's 18.9.
That's right. And you see it's also got the white space explanation. And the reason for the white space explanation is because the notes tell you that you've got to put in the white space to explain how you've arrived at the figure that's in box 15. Paragraph 11, please. Lord Hodge observes that it's the TMA which deals with the making and processing of claims for relief. Paragraph 12 is a very helpful summary of the ratio in Cotter. Paragraphs 13 to 17 analyses section 42. You'll see that Lord Hodge may help Lord Carnwath at the top of page paragraph 14, top of page 635. This is in 14. He explains the legislative history in terms of how these provisions were reworked just prior to self-assessment.
Yeah.
Then paragraph 16 deals with section 4211. 17 deals with 4211A. Schedule 1B, he goes through in paragraph 18. 4 deals with that counterfactual computation. So you're looking at how the tax, how it would have been payable. And you'll see it's at the top, it's in paragraph 19, about 6 lines on, there's that reference to the counterfactual assumption. Paragraph 2.2 of Schedule 1B disapplies section 42.2, so that's the requirement to include the return in a tax year. So in relation to including the claim in the return. But you see he says that at the end that disapplication does not mean that the taxpayer is released from making the claim in his tax return in year 2. Then Schedule 1A, and it deals with those various provisions. Then paragraphs 18 to 20 analyses, we've done that Schedule 1B, 21 to 22 analyses Schedule 1A, 23 analyses Section 8, 25 is analysis of Section 9, 26 to 27 address sideways loss relief, and 28 to 29 address the carryback position. And you'll see it's paragraph 31, where Lord Hodge says that where the revenue had not opened a Schedule 1A inquiry, the effect of the Schedule 1B26 is that in closing the Section 9A inquiry into year 2, it would be open to HMRC to amend the amount chargeable to income tax for year 2 in order to recover the sums which were wrongly paid as relief. And that's, as I say, I believe why the Court of Appeal referred to it would be a cash flow advantage in this case. And then you'll see paragraph 37 identifies some differences with Cotter. Can I then go to Cotter, which is MS 44?
Can I just ask, can I take it that the provisions relating to trading loss relief that were being dealt with in De Silva included a subject to provision?
Yes, yes. Then can I ask you to turn to Cotter, which is 443.
And tab,
It's tab 6A, MS 443.
Thank you.
Hard copy 6A. Paragraphs 3 to 4, it's MS 696. Paragraphs 3 to 4, we see from that this is an employment loss, and the claim is made on the face of the Year 1 tax return. And the only difference between Mr. Derry and Mr. Cotter is that Mr. Cotter did not complete the tax calculation pages. And we do say in circumstances where the self-assessment sum is correct, why should completion of the tax calculation pages, we would say correctly, make any difference to the correct inquiry procedure? Can I ask you to look at paragraph 14, please? Because this was a paragraph that the upper tribunal said provided a strong pointer that Schedule 1B did apply to share loss relief. Because do you see
which paragraph?
Paragraph 14.
Yeah.
And do you see Lord Hodge says subsection 7 provides this chapter is subject to paragraph 2 of Schedule 1B. So this is the signpost in the Income Tax Act. He then says this, section 4211A provides the same. Schedule 1B to the 1970 Act has effect in respect of claims for relief involving 2 or more years of assessment. It's not disputed that Schedule 1B applies to Mr. Cotter's claim for relief. So Lord Hodge is saying that section 4211A has the same effect as the signpost in the Income Tax Act. And so that's why I was saying that section 42.1 is important. Once section 42 applies, section 4211A has the same effect as those express signposts. And I say the upper tribunal, it's paragraph 57, I believe, said that was a strong pointer.
And did Lord Justice Henderson think the same?
He didn't refer to it.
Right.
I believe. Paragraph 16 deals with the entitlement to carry back loss relief. And this is the point, it doesn't countenance by virtue of the relief any alteration of the tax chargeable and payable in respect of Year 1. Paragraph 17, much the same point. It doesn't affect the amount of tax which is chargeable or payable in relation to Year 1. And having established in 14 to 18 the legal effect of the carryback loss claim, Lord Hodge in paragraphs 19 to 28 addresses the correct procedure for inquiring into a carryback loss relief claim. Paragraph 19, you'll see that the revenue were arguing Schedule 1A, and the taxpayer was saying, no, you have to put in issue a Section 9A inquiry. 20 to 21 discusses the advantages and disadvantages. Paragraph 22 records the revenues argument about the return, what the meaning of the return is, that not everything in the tax return form is included in the return, and why that is so. And then paragraph 23, Lord Hodge says it's important to recall the sequence of events in that case, that this is the fact it was submitted before the 31st of October. And then 24 and 25, Lord Hodge goes through what is included in the return. And in paragraph 25, you'll see that one of the examples that he gives of of a box that's not relevant to, not included in the return because it doesn't feed into the year one assessment is the carryback loss box. Now, he refers to the box on A13, but that's the equivalent of the box 15 on the tax calculation page that that the Court of Appeal rely on. Then can I deal with paragraph 27? Because this is the paragraph relied upon by the Court of Appeal
Yes.
in this case.
Well, one of the three. 27, 28 and 34, I think.
Yes, but yes, I'll come on to it, but I think it's really paragraph 28 when there's the crux, because they say matters would have been different if the taxpayer had calculated his liability by requesting and completing the tax calculation summary pages of the tax return. In such circumstances, the revenue would have his assessment that as a result of the claim, specific sums or no sums were due as the tax chargeable and payable for 0708. Such information and self-assessment would, in my view, fall within a return under Section 9A of the 1970 Act, as it would be the taxpayer's assessment of his liability in respect of the relevant year. And that's why I was saying my submission is relevant to consider that this was a paper return, and so therefore if he'd have called for the paper return, he could have manually entered in box 1 the figure. And that was the interpretation of 27 that was given by the upper tribunal in Rouse number 2. Can I just ask you to turn to MS 817?
And the tab number?
Is 11. Now, Rouse was a share loss relief claim, but the difference in Rouse was that the issue 1 point wasn't taken. But the issue 2 point was taken. So, in Rouse, the box 1 self-assessment, the box 1 figure is the correct figure, but box 15 was ticked. And you'll see that at paragraph 13, the upper tribunal explain their understanding of paragraph 27, and this is entirely consistent with our case.
Paragraph 1-3.
So it's 13 and 14.
Yeah.
You see, he says, in 27, Lord Hodges dealing with a taxpayer who brings a year 2 claim into his self-assessment for year 1, thereby reducing the tax due in respect of year 1. He says, by F, he must therefore be contemplating a situation where erroneously such a claim has been brought into the year 1 self-assessment. And it explains that that's not what Mr. Rouse did. The calculation of the year 1 liability took no account of the year 2 claim for relief and revealed a total sum of 1049,061.05. That's the box 1 figure, which HMRC agree is correct. Same position in our case. We agree the 95,000 figure is correct. The value of the relief was brought only into the calculation of the payments Mr. Rouse was required to make, and that's that 31st of January figure, but that calculation does not form part of the self-assessment. Indeed, and this is the point I was making earlier, it includes other sums, the payments on account, which are also proper only to year 2. So that's that first section 59A payment for year 2. And that's an important distinction. So we say that is our case. Lords, can I ask for 10 more minutes just to finish up on issue 2?
Yes.
Because I haven't actually got to the computation and the tax return. Can I just check to see if I've got... So we say our case, exactly like Mr. Rouse's case, that analysis applies. Because the return is completed in the same way. Box 1 has the correct figure. Box 15 has the claim for tax repayment for year 2. Upper tribunal say that box 15 figure the box 1 figure is the correct figure, and the box figure doesn't feed into that section 91B self-assessment, its only relevance is to the amount payable, actually payable, on the 31st of January, which will include payments not relevant to year one. For example, the payment on account for year two. Can I then please, can I just give you, can I highlight paragraph 62 in NIBS, in the High Court in NIBS? It's MS 825 and it's A tab 12, page 574. And it's also 62, because in 62, Ms. Justice Warren says there's a conceptual difference between the right to carry back a loss and the mechanism for exercising that right. And that's this point about the right is, yes, the right is contained in ITA, but the mechanism is in TMA. So that's paragraph 62. He goes on in paragraph 62 to say, the word claim is apt to refer to both the right and the mechanism. And then he says, if the right is exercised in two documents, for instance, in the year one return form and in the year two return, then there are clearly two separate assertions of the right, and in that sense, two claims. But equally, there is only one right to carry back the losses, and in that sense, there is only a single claim. And so, in my submission, it's an important point, and that's why you can't have, the claim can't be both inside and outside the return. And then similarly, 63 to 64 are also relevant. Can I give you the reference in paragraph 16 to Lord Carnworth in Blackburn and Keeling, and that's MS 687, and it's paragraph 16. That's just the point about the freestanding credit that Schedule 1B gives rise to.
I'm sorry, which paragraph?
Sorry, it's paragraph 16.
Thank you. Of NIBS?
No, that's Blackburn and Keeling.
Thank you.
And the tab?
Sorry, that was tab 5.
And you say NIBS is currently under appeal?
On appeal to the Court of Appeal. Sorry, I should have also referred you to 82 of NIBS, where they say, and that's MS 847, the self-assessment is not just the figure stating the amount due, but is every element of the calculation that goes to the tax chargeable in the year.
You say NIBS is correct, but it's
Yes.
subject to appeal.
Can I deal with the tax return and the personal tax computation in this way? The Court of Appeal relied on both the personal tax computation, which was is separate to the return, as well as the tax return. But when you look at and this is in the bound volume, can I start with the personal tax computation, please? And so that is MS 174, and it's page 173, tab 7 of the hard 173. I say MS 174. In my submission,
Right.
you'll see that this shows that the return has been completed correctly, computed and
Sorry, you have the hard copy page again.
173. So it's tab 7, page 173.
This is the year one
Year one.
tax computation.
And you'll see, we say that this shows that it's been done correctly, because the first stage is step one, the putting together the income, the various sources of income. Do you then see deductions? So that's step 2, nil has been deducted. Then step 3 is the allowance is deducted. To those chargeable amounts, the tax rate is the tax rate's applied. So that's the income tax due. So that's the section 91A figure. Then the 91B figure is arrived at by deducting from that the tax deducted at source, and that gives you the 95,000 figure. So that's the total liability figure. That's the section 91B, chargeable less tax deducted at tax chargeable less tax deducted at source. Then what you have is the payments due. And the starting point is that section 91B figure. And you'll see that the quirk in this case is that Mr. Derry didn't make any payments, section 59A payments on account, in respect of 0910. And as we'll see, he claimed to reduce the payments on account for year 2 to 0. So those 59A and B figures don't arise. But that doesn't mean, and so that's why it says total tax for 0910 is 95,546. The next line is 2010-2011 tax reclaiming now. So that correctly describes it. It describes it's the 2010-11 year 2 tax that's being reclaimed, and you'll see that that's set off against the 0910 figure to give you what they describe as the tax refund. But that's telling you what is either paid or repayable on the 31st of January. That is so is demonstrated by the year 2 tax computation, which you will see at MS 196, hard copy 19.
Hold on, I'm just looking at this still. The 165,800 is 40% of the loss relief.
Yes, so that's the box 15 2010-11 tax repayment.
Yeah.
But do you see how it's described?
Yes.
Sorry.
Yeah.
Taking it too quickly.
So rather than putting in the 400-odd thousand relief and then.
Sorry, I took it too quickly.
It
was step 2. So
yeah,
if my learned friends were correct, if my learned friends were correct, it should have been that they were deducting it from year 1. It would have been in step 2, where that deductions line is. It says nil. It would be there. And when you look at the appendix 2 to my learned friends equivalent calculation, they have the figure there.
And is that why he's got a figure for on account, which goes back up to the figure of the liability, leaving that to one side? He's gone back. He wants.
So yeah, that's why it's underneath there.
Yeah.
It's because do you see? So it says it's reduced to 0.
And it relates back to the 95,546, which came out of the first part of the calculation.
So the way, yes, well, it's calculated by reference to that, because that's the preceding year self-assessment. Yes. Exactly. Whereas if his self-assessment was a 0 minus 70 figure, you wouldn't need to make the claim because there would be no payment. So that's why I say that claim itself is inconsistent with a self-assessment of minus 70. It's only consistent with a positive self-assessment, as in a self-assessment in a positive sum.
So the passage from payments due is an add-on. The actual operative return is all that's above that.
Exactly. Well, the above that is how you get to the section 981A chargeable tax, 91B payable, the tax payable, which, as I say, doesn't take into account the tax you've already paid, payments on account, and then below that line is working out what actually you're going to have to physically hand over. And that is right, we see from the next year.
Sorry, what is the date of the document at page 173?
So this document, there was a dispute in the upper tribunal as to whether it was included in the return or not, but it was Mr. Derry's witness statement that before he signed off his return, he was shown this page.
What date?
Sorry? No, it's not. I think this is when these documents were printed off. But it's...
No, I'm sorry, it was just for an innocent question. Which year was this document produced in?
Oh, so it's produced so when he's completing his year 1 tax return, before they give him his year 1 tax return to sign...
Yes, sometime in late 2010.
January 2011.
Yeah,
yes.
Well, that's what I'm trying to get at.
Sorry, I was...
Yeah.
But you see, Lord Justice Henderson said, this makes it clear, this computation, he says, makes it clear that he was calculating his year 1 91B self-assessment by setting off the year 2 loss. But as I hope I've demonstrated, that's not what he's done. If he was doing that, it would have been at that deduction stage.
Which was the other document you're going to refer
I wanted to take you to the 11, so the year 2 computation is at MS 196, hard copy 195. And just to show you the payments, so you'll see that it's got nil on deductions, but that's because he's already claimed the benefit of the relief and you can't get it twice in the computation. But if you look at payments due, start with income tax due is the section 91A figure. That's the chargeable amount. Do you see then they've deducted tax deducted at source and the tax credits? And it's the tax credits which is the other amount that you can deduct in reaching the section 91B figure. That gives the tax liability, which is 11,426.50. That's the section 91B figure. But then look at the payments due calculation here. The payments due, they start with the 91B figure, 11,426.50. They then deduct the payments on account that, having claimed the right not to make any payments, he does seem to have made some payments. So they then deduct those two figures to get to the nil balancing payment due. Do you see that? Mm-hmm. So that's the section 59B figure. Then they add on to that the first payment on account. So that's the 59A for year 2, for the next year. And that gives you the total payment due for 31st of January 2012, that figure. And then you see it has the second figure as the second payment on account. And so in my submission, that shows, so that demonstrates what the payments due in the previous year.
It seems to show that on your approach, he hasn't actually claimed the relief in the computation for either year.
No, but the reason why is when we come to look at the tax return, what he did in the year 2 tax return, and I can show you that, the relevant page is at MS 208, it's page 207.
Hard copy 208.
Hard copy 207, MS 208. So this is the year 2 tax return. And do you see box 6 includes the loss? So for this, for the year 2 return, he requests the capital gains summary pages, which he didn't request and complete. Sorry, he didn't complete for the year 1 return. So this is the starting page is hard copy 197. I'm not sure if Lord Reed's looking for that.
Yeah.
Yes, 197 was the start page. MS 208 though is the one page that I think is relevant, because do you see he for the year in respect to which the loss relates, and he understands the loss relates, he calls for the CG pages and includes the total losses of the year. But the reason why it doesn't appear in the personal tax computation is because do you see boxes 12 and 13? 12 says that he's not claim against that year, and 13 he's already done in respect of the previous year. And so these clever algorithms, so he's complied with his obligation to include the chargeable amounts. So this forms part of his self-assessment for year 2, but because he's already had the benefit of the relief in doing the personal tax computation, it's cancelled out and is nil. And I say those pages are not completed, not filled out for year 1, recognising that they are losses that in law relate to year 2.
Mm-hmm. Can I ask on the page before the calculation you first took to, in the hard copy it's page 190. I'm not sure what page it is in the MS numbering.
Yes.
We see in the box for any other information.
Yes.
We're told the reduction. Well, first of all, we can see under box 15.
Yes.
What's said there.
Yes. So
we're told that the reduction in tax payable in box 15 relates to the loss carryback claim arising from the carryback of losses. The corresponding reduction in tax payable in the year ended 2010 is, and then we see the figures.
Can I explain that?
Yeah.
Because of course these are the boxes that are relied upon by the Court of Appeal.
Yeah.
And in my submission, again, it's the same mistake. The Court of Appeal have assumed that's the Section 91B tax payable. But of course, first point, this white space is expressly stated to be an explanation of box 15, not box 1. So that's the first point. The second point is those opening words, the reduction in tax payable in box 15, well, you've got to look and see, well, what sums does box 15 reduce in this return?
Well, it results in the net repayment.
Well, sorry, but the point is it doesn't reduce the self-assessment. Boxes 13, 14 and 15 all reduce the sums that are payable on the 31st of January. And the way you...
Well, you're saying that, but I mean, one can obviously see how the form has been filled in and how the calculation's been done. It may have been done ineptly. But what it tells us in paragraph 16 is that this is a loss carryback claim arising from the carryback of losses of 414,500.
But my lord, it's the reduction is in tax payable in box 15. Boxes 13, 14 and 15 are not reducing the section 91B tax payable in the year.
Well, no, but it goes on, that's what he says in the next sentence. The corresponding reduction in tax payable in the year ended 5 April 2010.
But again, here, as we see from the opening words, tax payable is not being used in the sense of section 91B. It's being used in the sense of the amount payable on the 31st of January. And this, is, with respect, is the mistake the Court of Appeal made, is that where it says they relied on the top heading, adjustments to tax due. But when you look, and it's worth just going back a stage, if we look at the preceding page, you've got a box that deals with self-assessment. One is the section 91B figure. Do you see one says total...
So which page are you on now?
So I'm on hard copy 189.
189.
I'm
finishing this.
So do you see box 1 says total tax student loan repayment class 4 next due before any payments on account. And we know that the before payments on account is the section 91B figure. So it's the chargeable amount less the tax deducted at source. So now that's boxes 1 to 6. Underpaid tax, we know that that's boxes 7 and 8. They don't feed into the 09-10 self-assessment. They are collection boxes. They relate to earlier, and they relate to other years, earlier years.
Yeah.
And they are collection boxes.
Yep. You
then look at payments on account. That's the claim for the year 2 payments on account. Again, they don't feed into the year 1, the 9-1B self-assessment. And then blind person surplus allowance, these do, but they are claims made in the body of the return. And then you get to 13, 14 and 15. Look at 13 and 14. They are underpayments or increased payments from the earlier years. They don't feed into the section 9.1b for the year. They only adjust the amount you have to pay on the 31st of January. And that's the same for 15. Can I just...
I think we've got your point.
Yeah.
We're going to have to press you to draw to a close fairly quickly.
Well, I think you have the point. I mean, that's what we say is the fundamental premise of, and can I just give you the paragraph references? When you go through paragraphs 55, 57, 58 and 63...
Of what?
The Court of Appeal's judgment, they proceed on the basis that adjustments to tax due is a reference to the section 9.1b self-assessment of tax payable, the section 9.1b figure. Whereas it is clear, in my submission properly read, that they don't relate to the section 9.1b figure, they relate to the payments due. And can I just make this point, is that you'll see the rubric adjustments to tax due are all examples of Schedule 1B claims. Farmers and the artists.
Where are you looking now?
Sorry, this was hard copy 190. I think it'll be MS 191.
Right.
The rubric under adjustments to tax due.
Yes.
The examples that are given are the Schedule 1B example, the farmers, the artists, and the carryback loss claims. And we know that those claims relate to year 2, given effect to in year 2. But can I just finish on the final point? I'm very conscious of the time, and I apologise for overrunning. Can I just finish up? The revenue, we don't accept, our starting point is we don't accept that the white spaces are part of the self-assessment anyway. The way the return is designed is that if you fill in the relevant boxes, you get to the right figure. But in any event, here, the box that's relied upon, 15, doesn't reduce the Section 91B self-assessment, doesn't feed into the Section 91B self-assessment. And that's consistent with the correct legal treatment. And bear in mind that box 15 doesn't just apply to share loss relief, it applies to employment losses, it applies to trade losses.
Mm-hmm. And what do you say about the fact that the revenue actually refunded the
As I say,
the tax?
the part of the problem is that there were witness statements in the upper tribunal that explained what had happened. As I say, the revenue here, it's the freestanding credit point.
Yes, but the point is that they treated it as a claim for loss relief in respect of year 1.
No. So with respect, that's the point about the freestanding credit, is that it doesn't relate it to any year. It's not a freestanding credit against year 1. It's a freestanding credit against the running balance of account.
You say that's explained in the upper tribunal?
No, so the witness statement, which unfortunately you haven't got, it didn't feature in the Court of Appeal in the decision. But we absolutely don't accept that the freestanding credit is applied to year 1.
Well, you don't accept it, but the Court of Appeal obviously thought that was significant.
Well, with respect, the Court of Appeal say that there's a paragraph where they recite my learned friend's submissions. I'm not sure that the Court of Appeal...
You say they didn't have the relevant witness...
I don't know whether... That I don't know.
Well, would it be useful for us to see it?
I think it would. We have copies.
Yes.
But can I say this? That not only is my interpretation of the tax return consistent with the correct legal treatment, it's also, as I hope I've demonstrated, consistent with the personal tax computation that shows where the 2010-11 repayment features in the computation. It features below the Section 910.
I mean, you made that point.
Yeah. Oh. But with respect, the point here, though, is answering my Lord Reed's question about...
If you look at paragraph 11 of the Court of Appeal...
Yes.
They deal with it there and say that on the 18th of October 2011...
Yes.
It's in the hard copy at page 136. Yep. HMRC repaid a sum of 70,000 odds to Mr. Derry.
It's unclear the amount. Yeah.
Yes, but they're talking there about the difference between it's a few £100 difference between what he was claiming and what was repaid. But the payment was clearly intended to include the amount claimed by Mr. Derry, albeit HMRC now say the payment was made in error.
But with respect, so when he says HMRC now say the payment was made in error, that's based on the witness statement. Court of Appeal is not a fact-finding body, and with respect,
this court.
Well, no, but with respect, and I haven't had the chance to take you through the paragraphs, but what it's clear, when Lord Justice Henderson says throughout, it's clear the tax return was made on these assumptions. It's on the basis that, in my submission, he is conflating the Section 91B payment, tax payable, with the amount that's payable on the 31st of January.
But when he says it was accepted, it was made in error, was he wrong?
Well, because, as I say, the witness statement explains it.
Well, I know it does, but I mean, either somonne said this is, I mean, you were there.
No,
You weren't there,
I was not.
You weren't. Anyway, well, there we are, so you may not be able to help us, but it would be helpful if someone could tell us whether they accepted it was made in error or not.
Well, I
mean, not necessarily now, because I think time is moving on.
Yes, and the same point really arises in relation to paragraph 55, where they say that even if you ignore Mr. Derry's calculation, or his accountant's calculation, they say it's perfectly clear what he was intending to do.
But that was the
and
paragraph.
they add, moreover, this must be what the revenue understood him to be doing, because he was repaid the 70,000 odds.
Yeah, as I say, that's the submission. That's recording the submission of. It says there submits Mr. Derry. That was the paragraph I was referring to when I said that they record the submission.
Is that right?
Yeah, so you were just reading, even without the calculation, submits Mr. Derry. It is perfectly clear from boxes 1.
Oh, I see. Oh, yes, I see. Yes, that's the
Sorry, that was the point I was making.
So the problem is more relating to paragraph 11.
Yeah. I apologise for running over time.
Yeah, that's fine. Thank you.
Can I just ask, the question you asked me about were the witness statements before the Court of Appeal, I'm told the witness statement and the exhibits were before the Court of Appeal. And I say we do have copies of the witness statement and exhibits as well.
Yes. But Miss Nathan was before the court.
Yes, she was.
Sorry, I think.
Yes. Well, I was just about to ask Miss Nathan if she wished to follow.
Not at the time, thank you.
Now, Miss McCarthy, is it worth your while making a start just now? Do you wish to?
My Lord, I'm happy to make a brief start just now, if that would assist.
Certainly. I'm hoping that the fact that we've gone through the legislation in so much detail with Mr. Norbat may speed you on your way somewhat.
Yes, I'm grateful, my Lord, and I hope so too. May I just give your Lordship the reference in the upper tribunal's decision where the upper tribunal considered the evidence it had before it in relation to the refund. That is paragraphs 59 through to 65. It is core tab 7, pages 169 to 170, MS 170 to 171. And it may be that is worth a minute looking at over the short adjournment.
Which paragraphs then is it?
Paragraphs 59 through to 65.
Thank you.
And can you give us the punchline?
Well, the punchline is at paragraph 65. There wasn't enough evidence before the upper tribunal for the upper tribunal to be certain as to the facts, as to the circumstances in which the refund was made.
But it was made.
Yes, absolutely, my Lord. It was made. There's no question of that.
And was it said to be made in error in the Court of Appeal?
Well, my Lord, that is a little more difficult because the evidence of Mr. Dean was not the revenue officer who made the repayment. He was simply explaining after the event. And it is certainly the case that after the event, the revenue consider it to have been made in error.
Yeah, I see.
But we don't understand that it was some sort of computer glitch. Rather, our understanding is Mr. Derry's accountants chased for the repayment by way of phone calls and a letter, or certainly phone calls, and that prompted the repayment.
Yes, the way it's put is I'm not persuaded it would be right to make a final determination against Mr. Derry in relation to his contention that the payment amounted to HMRC giving effect to his claim to relief.
Yes, and the facts leading up to that were simply not sufficiently clear for that particular issue. But, my Lord, I think the same can be said in response to your question.
Yeah.
Maybe I had 2 points to make by way of introduction. maybe I might get through the
Yes,
first
certainly.
one. They concerned the context in which this appeal takes place, and secondly, the interrelation between grounds 1 and 2. Beginning then with context, it's important to reiterate the point we made in paragraphs 1 to 4 of our written case. That's pages 86 and 87, MS 87 to 88. This case isn't directly about HMRC's inquiry process. Rather, it's about Mr. Derry's tax calculation in his 09-10 return. And quite simply, the question is, did Mr. Derry reduce his tax due by $165,800 when he completed the tax calculation pages of his 09-10 return and spelled out expressly that he was reducing his tax due by $165,800. We say, unsurprisingly, in those circumstances, the Court of Appeal agreed with Mr. Derry that that was exactly what he'd done, and that any other reading of the plain words in the tax return was an impossible contention. That is Court of Appeal decision, paragraph 63, hard copy 151, MS 152.
You say, in a sense, you cut through the boxes points, is that right? You sweep those aside and say, what is the substance of this?
Well, it's what is the wording above the boxes. So we say sweep aside the personal tax calculation. That single sheet of paper was not part of the return. It was not sent to HMRC. We say the boxes on the tax calculation pages mean what they say. Now, once that question has been answered, then we say the correct inquiry procedure is obvious. If Mr. Derry's 09 tax due is reduced by $165,000, HMRC must open a Section 9A inquiry into that return in order to challenge his self-assessment, precisely because HMRC does not agree with his self-assessment. Many of HMRC's submissions focus on the inquiry procedure as a reason for arguing that issue 2 in particular is wrong, but the correct inquiry procedures are consequential to and don't assist the interpretation of his tax return, of Mr. Derry's tax return. If HMRC had any doubt as to whether to open a Section 9A or a Schedule 1A inquiry, then HMRC can and should open inquiries under both sets of provisions protectively. And just for your Lordship's note, that point was made in Cotter Court of Appeal at paragraph 30. That's Authorities tab 6B, page 461, MS 712. And I appreciate that the Cotter Court of Appeal decision was overruled, but that point is still valid. Had HMRC taken that obvious step, we wouldn't be here. But if they had done that, then HMRC wouldn't, cutting to the chase, have been able to send the bailiffs round to Mr. Derry's house in 2014, thus prompting Mr. Derry's judicial review. Rather, no tax would have been due until the inquiry and appeals procedures had run its course in the usual way. And if I may just have one more minute to finish the point on context. I make this point because one of the reasons why HMRC say they should be allowed permission to appeal is their bold assertion that there's £100 million of tax at stake in this issue. And that is paragraph 9 of HMRC's grounds. For your note, core volume tab 17, core volume tab 1, page 17, MS 17. Now, assuming for the moment that that is correct, and there's no evidence at all that it is, it's just an assertion, but that suggests that HMRC took a strategic policy decision not to open Section 9A inquiries into Year 1 returns, but instead to pressurise taxpayers into making payments of tax not actually due by threatening county court or other enforcement action. The real issue here, and the root of these proceedings, is can HMRC disregard what we say are clear entries in Mr. Derry's self-assessment return of tax due in order to go straight to enforcement action. We say, and the Court of Appeal agreed, that plainly HMRC cannot do that. My Lord, that would be a convenient moment.
Can I just pick you up on one point you mentioned
Yes, of
a moment
course.
ago? You said it was important to look at the words above the boxes. And I suppose in particular you were referring to the words above box 15. It's it's on page 190 in the hard copy.
My Lord, that is correct, but in particular the heading, so this is MS page 191,
Yeah.
at hard copy page 190. In particular, the subheading, adjustments to tax due,
Yes.
you may need to make an adjustment to increase or decrease your tax for 2009-10.
Because in particular you're carrying back to 2009-10
Certain losses,
from 2010-11.
quite so.
And the only box you could put those in would be box 15.
On the tax calculation pages, that is correct. There are other boxes in the tax return pages that complement that, that Mr. Derry completed.
Yeah.
And we also tie this in, as the Court of Appeal did, to the subheading above box 1, total tax ... due. What else can box 15 be doing?
Sorry, where are you now?
I'm sorry, box 1, page TC1, MS
Yeah.
190. That is headed total tax ... due.
Yeah.
What else can box 15 be doing when the rubric of the tax return form is read together, other than reducing the figure in box 1? And that is absolutely correct when you take that with the other information in box 16. We say the Court of Appeal was obviously right on that point.
Well, thank you. I think that's a high time for us to adjourn.
Thank you, my Lord.